People prefer tidy acts. I had learned that lesson long before the case that would reshape my life. But learning it again, this time under bright public scrutiny, taught me how dangerous tidy narratives can be. Grief is rarely a neat drama with a clear cast of heroes and villains. Our private calamity, once it crossed into public view, was reshaped by an appetite for absolutes, headlines that demanded saints and sinners, rallies that wanted an easily chanted target, soundbites that reduced a household's complex failures and loyalties into moral theater. I resisted that script not because nuance is inherently virtuous, but because accuracy matters. If the aim is to prevent repetition, outrage must be translated into practical fixes, not moral spectacle. To pursue practical answers, we had to begin with history. Conservatorship and guardianship are not modern curiosities invented overnight. Their roots run back through the 19th century, when states and courts first grappled formally with questions about property, capacity, and care. Across the 20th century, legislatures and courts built systems designed to manage the affairs of adults who could not reliably make or enforce decisions for themselves. Those systems were useful. They created mechanisms to hold property safe, to appoint someone to ensure medical and residential needs were met. But by concentrating authority in a small number of fiduciaries, conservators for financial matters, guardians for personal care, those systems also created opportunities for misuse. By the late 20th century, reformers were already warning of the risks inherent in consolidated fiduciary control. Scholars, advocacy organizations, and bar committees began to draft model statutes and proposals. These were slow processes of accretion. Reports piled up, conferences debated principles, and slowly a shared language about transparency and accountability began to coalesce. Practice, however, lagged. Courts and agencies continued to operate under older assumptions, and on the ground the protective intent of statutory regimes sometimes hardened into gatekeeping practices that left people captive rather than cared for. Two milestones frame the recent public conversation. One came in 2017, when national drafting bodies published a model act intended to modernize guardianship practice and increase oversight. The act was not a cure-all, it was a signpost. For the first time in many jurisdictions, lawmakers and advocates were speaking with a common vocabulary about mandatory reporting, narrower delegations of authority, and audit thresholds. The second milestone was less procedural and more media-driven. Between 2019 and 2021, a high-profile conservatorship, one that had in fact begun in 2008, became a near-constant subject of news coverage and public debate. The conservatorship's visibility turned a technical legal instrument into an everyday topic in millions of homes. Suddenly, ordinary citizens asked how a court could authorize long-term control over another adult's finances and personal decisions. That surge in public attention created a political opening. Lawmakers who had considered guardianship a marginal legal problem began to listen. Agencies faced public pressure to adopt concrete reforms. Our own story arrived into that wider swirl as a private calamity. For a time it remained personal: grief, confusion, and the legal obligations that follow loss. Then it became litigation, an intensely focused, adversarial process in which ambiguity must be sharpened into exhibits and testimony for a judge and jury. Litigation imposes order, but it also consumes you. Court calendars and discovery deadlines define days. Outside the courtroom, the media wanted spectacle. Within it, the work was detail-heavy and procedural. Some listeners wanted a headline they could hold up like an accusation. Others wanted an easy narrative of institutional villainy. I learned to resist those demands not from sentimental attachment to nuance but from necessity. Public policy is messy. It is negotiation between autonomy and protection, between families trying to care and families that exploit, between scarce resources and urgent needs. If reform was to be durable, it had to address the practical points where the system failed. Litigation eventually produced a settlement. The settlement returned resources to the estate. Money that had been misdirected and that rightly belonged back. Restitution was necessary, and for a while it felt like the end we sought. But restoring assets was only the start. Money returned to an estate does not, in itself, change the legal and institutional architecture that permitted abuse. If the same statutory ambiguities, bookkeeping blind spots, and cultural indifference remained, the chance of repetition would persist. So we set a sequence of work in motion. The order felt natural in retrospect. First secure immediate needs, then document failures, design practical fixes, and finally, test those fixes in real-world institutions where they would need to work. The first practical move was transparency. We published a careful public account of the settlement and the processes leading to it. Not the entire litigation record, but enough to show what had happened and why certain remedial steps were being taken. That choice was not legally required, but legitimacy accrues from openness. Making a portion of the record available helped orient advocates, researchers, and concerned citizens. It allowed others to see patterns rather than merely consume a moral tale. Next, we focused on language and protocol. Conservatorship statutes and the case law interpreting them are often written in broad strokes. That imprecision becomes a doorway. A vaguely defined authority becomes an invitation to exploit. So we drafted model language with the precision lawyers give to trust instruments, specific triggers for oversight, tight definitions of permissible transfers, and mandatory notice provisions for significant asset movements. We produced a checklist for judges considering a conservatorship petition. Questions as basic as whether less restrictive alternatives had been tried, whether the proposed conservator had a documented history of independent fiduciary behavior, and whether periodic accounting requirements would be enforceable. We wrote guidance for banks explaining how to spot irregular transactions that might indicate coercion or undue influence. We assembled an intake form for social workers to flag signs of financial exploitation. Sudden changes in banking behavior, coerced signatures, abrupt alterations in caregiving arrangements. These documents were mundane, but they were durable. They inserted guardrails into everyday practice. As those materials began to circulate, we turned to institution building. We established a foundation to hold and allocate the resources we hoped would have a lasting impact. The foundation's earliest work resembled that of many new nonprofits, triage. We made small emergency grants to prevent evictions, connected families with pro bono lawyers to contest improper conservatorship nominations, and helped stabilize households at immediate risk. But the vision was broader. We began to build programs with a longer horizon, legal referral networks to connect families with counsel who understood fiduciary law, small emergency grants to stabilize households on the brink of displacement, and a fellowship to support early career attorneys focused on fiduciary issues. The fellowship served two purposes at once. It gave young lawyers the time and space to learn a difficult field, and it seeded a culture of practice that treated fiduciary responsibility as routine and professional. Those projects did not launch all at once. They arrived in an order that now looks like a sequence of necessary moves. Transparency first, to build legitimacy. Protocols second, to standardize responses. Institution building third, to create the capacity to respond consistently. Then came the slow work of testing, pilot programs in specific courts and clinics, evaluations of bank partnerships, and feedback loops with social workers who used our intake forms. Practical reform required iteration. We learned from failure as much as from success. A checklist would work in one county court but prove unwieldy in another. A bank training module that resonated with regional staff needed retooling for a national bank's compliance system. Each iteration made the tools more robust. When the foundation reached its 10th anniversary, the feeling was less celebratory than reflective. 10 years is a punctuation mark, not a finale. The anniversary report we published was dense with charts, case studies, and attributions. A document intended for practitioners, policymakers, and philanthropic partners rather than for headlines. Using anonymized examples, the report traced how a modest emergency grant had prevented an eviction that would have fragmented a family, how a specific clause in a conservatorship petition had blocked an opportunistic transfer, and how legal referral networks had connected caregivers with counsel who could contest overreaching conservatorship nominations. At a small public event we convened for the anniversary, I listened as researchers, relative produced a questionable power of attorney, and preparing testimony that translated private horror into a coherent, actionable narrative for committees and courts. The work was tactical: learn to condense a private calamity into a plain statement when you testify, prepare charts for a committee hearing, hold public attention without letting the story become spectacle. These sessions were also pedagogical exercises in temperament. Fire was useful, it needed to be harnessed. Those committee rooms became a distinct chapter in the chronology of reform. Until the late 2010s, guardianship was an arcane area for most lawmakers. Between the publication of Model Acts in 2017 and the surge of public attention from 2019 to 2021, legislative bodies began to confront oversight gaps more concretely. I stood in hearings and said plainly what had happened to us and what could be done. Lawmakers asked the operational questions: oversight, cost, implementation. They wanted solutions they could vote on. In those rooms, the private damage began to become public policy. The hearings were strange places of exposure and empowerment. A private account reduced to charts and marginal notes, weighed against budget spreadsheets and implementation timelines. One concrete legislative outcome at the state level illustrates the nature of incremental reform. It was not the sweeping overhaul some advocates sought. It was procedural and specific. Paid professional guardians were required to file more detailed reports, and accounts exceeding a specified threshold were subject to mandatory audits. Specificity matters. A narrow statute, properly enforced, makes compliance measurable and creates clear failure points for oversight. I learned to trade narrative horror for data and operational proposals. Arguments that a legislator could accept as both principled and feasible. Evidence and research turned out to be crucial in moving from outrage to durable change. The foundation funded empirical studies into aging, mental health diagnoses, and financial decision-making. The findings were sober and sobering: social isolation, concentrated caregiving power, and lax auditing repeatedly appeared as risk factors. Those patterns allowed us to make specific recommendations in hearings and rulemaking proceedings. When anecdote alone drove the conversation, reform felt sentimental and ephemeral. When evidence backed proposals, they became defensible in committee rooms and administrative proceedings. Research became our armor. It moved the debate from moral complaint to persuasive policy. As our materials and programs circulated, the culture of practice changed slowly. The fellowship alumni carried new routines into public defender offices, legal aid clinics, and guardianship oversight boards. In clinics, they asked bank clerks to flag irregular transfers. In court, they insisted on intake forms that documented potential coercion. In community settings, social workers used toolkits that made it easier to spot exploitative patterns. The normalization of these practices felt revolutionary precisely because it was quiet. The routinization of careful fiduciary behavior, the idea that fiduciary responsibility belongs in the ordinary work of a profession, proved central to preventing exploitation. Running a nonprofit is perpetual triage. Fundraising, personnel management, compliance, and program evaluation consume time and attention. For me, those institutional demands competed with private mourning and the desire to write. Delegation was uncomfortable at first. Entrusting mission-critical work to others felt risky. But delegation became a form of trust and, ultimately, of stewardship. Letting skilled people take responsibility did not dilute the purpose, it sustained it. The mission ceased to be mine alone and became institutional muscle. Those institutional muscles enabled private recoveries too. In the bleak months after litigation, I found small, concrete rituals could anchor me. I began a rooftop garden, herbs and tomatoes coaxed from stubborn soil and wind. I took up a camera and learned to pay attention to light. Often in the afternoons I walked to a community garden by one of the housing projects our foundation supported and put my hands in the same soil as neighbors who juggled other priorities but shared similar care. Gardening was mundane but steady work: planting, weeding, watering. The slow accumulation of green things, seedlings that grew into fruiting plants, acted as an antidote to legal theater. Repair, I learned, is both policy and practice. Drafting clauses to protect someone's wishes and remembering to water a bed. Memory remained a presence, arriving unpredictably. For years, the cadence of a courtroom procedure, how a witness's sentence trailed off, the hush of the gallery, would jolt me awake. Over time those nights grew less frequent, but they did not disappear. I learned breathing techniques and small rituals. Call a friend, sit on the porch and play a playlist my husband loved, or open one of his lab notebooks and read it not as evidence but as conversation. That notebook became a hybrid object, relic and living text. Memory itself felt less like a single thing than like a palimpsest. New pages wrote over the old, but they did not erase them. Learning to hold both together, the ledger and the music, the paperwork and the tenderness, became part of surviving. Not every rupture could be mended. My relationship with my parents settled into thin civility and unresolved questions. We spoke for practical reasons, healthcare proxies, estate forms, logistics, but the warmth of old embraces did not reappear. That kind of structural rupture is not necessarily a failure. It is, rather, a reallocation of emotional energy. I accepted that certain losses could not be repaired and that grief had to be housed without becoming the engine of each day. Instead of insisting on whole family belonging that was no longer possible, I built a constellation of sustaining relationships, friends, colleagues, and people the foundation had helped. Those ties were not blood, but they were real and steady. As the foundation entered its second decade, the work shifted toward sustainability and governance. Institutions have life cycles. A mission dependent on a single personality will not survive the founder. So we built an endowment and governance structures intended to outlast me. We insisted on a board that combined legal expertise, nonprofit management, lived experience of caregiving, and fiscal oversight. Those conversations were uncomfortable at times. They required letting go and confronting questions of power and authority. Drafting bylaws, specifying endowment stipulations for clinics and emergency grants, and recruiting a fiscally responsible treasurer felt like closing loops, turning private pain into public competence. Good governance meant knowing when to speak and when to listen, creating mechanisms to resist mission creep, and normalizing oversight. Ceremonies marked progress without pretending to finality. A small public panel where a tenant spoke about how an emergency grant kept her child in school, a fellowship alum returning to report a victory in a guardianship hearing. These were punctuation marks, not finales. The work remained unfinished. Measurable outcomes were real: grants seeding discovery, tenants whose housing stabilized, procedural tightenings at the state level. But the reforms were cumulative rather than singular. A clause here, an audit requirement there, an intake form beginning to flag coercion. These accretions matter because they aggregate into systemic change. Mentoring continued as one of the foundation's most visible outputs. Young attorneys who began as volunteers became practitioners, embedding best practices into everyday lawyering. They celebrated unglamorous victories: a neighbor successfully contesting a conservatorship nomination, a bank asking for a second signatory on a large transfer, a social worker flagging exploitation before it turned into a crisis. Those small wins were proof that change had taken hold. The quiet shift, fiduciary responsibility treated as routine, felt revolutionary because it was not flashy. There were private costs to running this work. I wrote less, I had fewer agenda-free days to mourn. Accepting limits became part of surviving the long haul. Delegation, once a painful concession, became essential. Trusting others to steward the mission honored the intention that had motivated the work in the first place. Programs matured in parallel. Emergency grants and referrals remained important, but they gave way to organized workshops, research projects, and a fellowship with a curriculum. Pilot research grants produced data that informed state policy discussions. Where anecdote once held sway, empirical rigor made reform more defensible. Evidence is not a magic wand, but it is persuasive currency in legislative halls and administrative proceedings. Personal rituals persisted. I marked anniversaries quietly, a photograph taken in a new place, an evening reading a saved email aloud, a plant set out to bloom in a season I might not see. Those acts were companionable rather than performative. Grief permits intimate rituals that do not seek public validation. They sustained me as much as any public recognition. There were still nights when memory arrived unbidden, a lab notebook left open on a table, an old voicemail, a photograph tucked behind a file. Those moments became private currency. I learned not to confuse them with failure. Instead I held them and paired them with public action. Grief, in a complicated sense, became generative, a moral urgency that propelled steady, non-spectacular work. If I had to distill these years into a single principle, it would be this: stewardship requires both stubbornness and softness. Stubbornness to insist on procedures, to litigate when necessary, and to demand transparency from institutions that might otherwise obfuscate. Softness to remember human frailty, to design programs that heal rather than merely punish, and to accept the imperfect nature of repair. Legal instruments are tools. Empathy is the motive. Together they form a practice that honors loss while preventing its duplication. The story is unfinished. New cases will appear, new laws will be tried, and new families will call with trembling voices. The public appetite for moral clarity will insist on heroes and villains, but real life resists those categories. Reducing everyone to a moral label is unhelpful. Complexity requires care, and care requires institutions that can sustain practice over time. Our concrete achievements are modest but real: restored estate resources, oversight protocols that make misuse harder, an endowment that funds clinics and emergency grants, workshops that build family capacity, a fellowship that trains new fiduciary stewards, a community garden that keeps producing, a fellowship that keeps training practitioners, a governance structure that outlives a single leader. These are the inheritable things I hope remain. They are steady, accumulative repairs. There remain unresolved family fissures, patterns I have come to accept as structural rather than merely emotional. Contact with my parents is practical and minimal. Forgiveness is not a requirement I impose on myself, it is an option that requires willingness from both sides. In the meantime, the constellation of friends, colleagues, and beneficiaries of our work has become my sustaining network. As the foundation moved fully into its second decade, concentrating on institutional durability required a kind of pragmatic letting go. Establishing an endowment with clearly stipulated funds for legal clinics, the fellowship, and emergency grants required imagining a time when my daily involvement would be limited but the principles we had fought for would persist. That planning, unromantic and precise, felt like a completion of sorts. There remain nights of private remembrance, and I do not try to hide them or to turn them into a neat story of triumph. Memory is not a failure to move on, it is the ledger of a life loved. Because I have learned to pair private remembrance with public action, grief has become a propulsive force rather than an exclusive identity. The ledger balances not with dramatic closure but with a steady record of cumulative repairs. That is the inheritance I hope to leave, not a single chapter closed, but institutions that notice when a neighbor needs help and ordinary practices that keep fragile intentions intact. Finally, I expect to remain part of this conversation as long as my experience is useful. New cases will come, new laws will be tested. The comfort is continuity, the knowledge that this work can outlast any single person and that small acts, a clause carefully drafted, a fellowship stipend paid, a garden bed tended, sum to something that endures. In a world that favors tidy acts and crystallized moral narratives, I have chosen a different posture. I have chosen repair that is slow, accumulative, and boringly durable. That, more than any headline, feels like a worthy use of grief. When he died in late 2010, the first months were all form and paper. There were funeral arrangements, the immediate sorting of household affairs, and the blankness that follows the sudden absence of someone who had been both partner and co-investigator in a life of shared work. Those first weeks felt like a public administration. Name change on a mailbox, closing a lab account, the necessary but mechanical kindness of friends who delivered casseroles and folded themselves into the calendar of practicalities. It was a month after his burial, in January 2011, that my parents filed the first petition. Their petition asked a probate court to declare me mentally unfit, and to appoint them as conservators of my person and estate. They alleged that grief, a need for professional oversight, and what they called a pattern of poor judgment, rendered me incapable of making financial and medical decisions. They moved, at the same time, to be named co-administrators of my late husband's estate. A $4 million portfolio composed of a modest home equity, a set of retirement accounts, and a series of grants and research endowments that were in various stages of disbursement. The legal instruments they invoked were familiar to probate lawyers: emergency petitions for temporary conservatorship, requests for immediate control over bank accounts, and affidavits repeating the same few claims. The immediate legal question was straightforward: Could they prove incapacity before a judge, on the basis of record and expert evidence, in a hearing that the court expedited because of the alleged urgency? The family theater that followed is, by now, a familiar script in guardianship cases. Petitioners circulate anecdotes about missed dinners, late emails, and halting speech. They nominate caretakers and suggest that money be placed aside for your own good. What felt different to me then was the specificity of their ambition. This was not only about care, it was about control of a $4 million estate. I knew then that evidence would be my language. I gathered everything that might demonstrate competence and intention. The lab notebooks he had left open on the desk for me to peruse, pages of experimental reasoning and shorthand notes to future students, became more than memory. They were a demonstration of methodical thought, the arc of decisions made and recorded. I organized emails, bank statements, tax returns, texts with clear directives he had left about disbursements and bequests, and affidavits from colleagues who had consulted with me after his death on the administration of joint grants. I asked a trusted neurologist and a psychiatrist, both familiar with the subtle difference between clinical impairment and bereavement, to perform evaluations and provide reports. They concluded, in clinical language, that my grief did not amount to cognitive incapacity. Discovery exposed the contrast between narrative and record. Forensic accountants subpoenaed by my counsel traced a series of wire transfer requests that my parents had initiated to certain accounts within days after the petition was filed. Some transfers were stopped by my bank, which had flagged activity inconsistent with account patterns. Other transactions were routed into accounts associated with third parties who had, in later interviews, described being told that the money was being held for future care. Affidavits from neighbors and from the man who had once been my father's financial advisor indicated conversations that fit a pattern the court later described as chronic persuasion and an intensifying effort to consolidate control. The hearings that followed stretched, by necessity, over weeks. The courtroom became, for a time, the public lens through which private grief was refracted. In March of 2011, during a 2-day evidentiary hearing, the judge listened to expert testimony on capacity, to bank officials explaining holds and flags, and to me as I read aloud an excerpt from one of my late husband's notes that laid out his wishes for the disposition of certain research funds. The judge permitted cross-examination. The hearings were procedural and, in their way, humane. At the end of the second day, the court denied the emergency conservatorship petition, ordered an independent temporary conservator for only those accounts for which the bank could demonstrate an immediate risk, and issued an interim protective order forbidding any transfers pending a full accounting. The ruling did not feel like vindication. It felt, rather, like a legal holding pattern that required more work. The forensic accounting, which concluded in the summer of 2011, recommended the restitution of sums improperly requested and the placement of certain assets under an independent trusteeship until a final determination could be reached. It concluded too that there was a pattern of undue influence consistent with coercive persuasion, language that would later be threaded through the briefs used by reformers to describe similar cases. By November 2011, after months of negotiation, motion practice, and a final hearing where a judge issued a comprehensive written opinion, I regained access to the accounts that had been improperly immobilized. The court's memorandum found, in legal terms that mattered for precedent, that the evidence did not support a finding of testamentary incapacity and that some of the petitioner's actions displayed an intent to circumvent the decedent's expressed wishes. The judge ordered the return of the bulk of the estate's liquid assets to the administration under my oversight, required the repayment of certain transfers, and imposed sanctions that included reimbursement of my legal fees. The outcome did not erase the family rupture, but it did place the $4 million estate back under the stewardship envisioned in my husband's notes and in the practical letters he had left. That stint in probate was the crucible out of which the foundation grew. If the immediate impulse after the victory had been private settlement, restore accounts, close files, mourn privately, there was another, less personal insistence that grew clearer with distance. I saw in the paperwork a template for abuse. The same forms and motions that had been used against me appeared again and again in legal clinics and probate filings across the state. Estate and guardianship law, as practiced, privileged those who had the knowledge to file first and the social capital to deploy a narrative of care in order to gain control. The work of the next decade would be to alter that architecture. We began in 2012 by establishing the foundation as a legal entity with a narrow mission, to defend the rights of people in transitions, widowhood, disability, elder care, from predatory or coercive fiduciary actions, and to professionalize the practice of stewardship. Seed money for the endowment came from a combination of sources: a portion of the restitution ordered by the court, gifts from friends who had been moved by the case, and an early bequest from a colleague. The endowment, modest at first, was designed to be strategic rather than grand. It prioritized pilot legal clinics, a modest fellowship for young attorneys, and emergency grants for people facing sudden guardianship filings. From 2013 through 2016, the Foundation's work was hands-on and legislative. We ran weekly clinics, funded pro bono counsel for contested probate petitions, and compiled case studies that proved useful when we began talking to legislators. In 2016, I testified before the State Assembly's Judiciary Committee, bringing with me a redacted copy of the court's memorandum in my case and a binder of anonymized client stories that showed patterns: petitions filed by relatives coinciding with financial activity, emergency orders used to freeze accounts without timely judicial oversight, and a lack of uniform requirements for banks to report suspicious transfers in conservatorship contexts. The committee, frustrated by a spate of highly publicized cases across the state, took an interest. One tangible outcome was a statutory amendment passed in 2017. The new law did three things. First, it required that any emergency petition for conservatorship that involved real property or transfers exceeding $50,000 trigger an immediate, court-ordered forensic accounting. Second, the law compelled banks to flag and to report, within 48 hours, any unusual transfer requests from accounts where a conservatorship petition had been filed. And third, it required courts to appoint an independent fiduciary for any case where allegations of undue influence were supported by more than a threshold of corroborating evidence. The language was not perfect, and the bill was the product of compromise with stakeholders including banks, elder law advocates, and probate judges. But it created procedural friction where there had been speed and opacity. It made it harder to weaponize grief. Our pilot clinics in 2018 and 2019 produced data that mattered in administrative holes. We tracked metrics: the percentage of emergency petitions that led to transfers we later categorized as suspicious, the time elapsed between petition filing and the appointment of an independent fiduciary, outcomes for petitioners who had professional counsel versus those who did not. These datasets were dry but persuasive. When we presented them in 2019 to a statewide judicial conference, a handful of trial judges admitted that the plots they had seen in courtrooms had been too often left unexamined. Procedural change, we learned, needed both legislative scaffolding and judicial buy-in. Meanwhile, the Foundation expanded its fellowship program. Young attorneys who began as volunteers matured into practitioners who absorbed a practice ethic that treated fiduciary responsibility as a public trust rather than a private opportunity. Fellows took internships with probate courts, served as guardianship monitors, and embedded best practices, second signatories on transfers above set thresholds, mandatory reports, and independent audits, into everyday lawyering. In 2020, one fellow who had clerked for a district judge helped draft a model local rule that a county court adopted requiring a written recusal standard for judges who had direct financial or familial ties to petitioners, an often overlooked source of conflict. There were costs, private and public. Media coverage that once framed my story as a simple melodrama of betrayal sometimes sought out my parents for pithy quotes. I declined televised confrontations. I did not want the work to be reduced to spectacle. Where possible, I pursued structural remedies rather than personal vindication. I also recognized that the story could be weaponized by others as a cautionary tale in the wrong direction, the fear that anyone grieving might be subject to second-guessing. Protecting the privacy of surviving loved ones became a part of our practice. We redacted names in the case files we used for research, and we worked with journalists who were willing to focus on systems rather than personalities. By 2022, the Foundation's endowment had reached a size that allowed multi-year commitments. A carefully managed portfolio and conservative spending rules produced predictable streams for clinics and emergency grants. We created a permanent archive, a curatorial decision as much as an administrative one, housing a copy of my husband's lab notebook alongside anonymized client files and the minutes of board meetings. That archive, housed in a university special collections wing and accessible to researchers by appointment, was intended as an evidentiary and pedagogic resource, raw materials for future scholarship on guardianship abuse and fiduciary reform. The relationship with my parents never healed. Contact remained, as before, practical and infrequent. They visited when there were medical updates to coordinate and when estate formalities required signatures. They retained their narrative, claims of concern, insistence that they had acted for safety, and I retained mine. The court's decision had vindicated my capacity and restored oversight of the estate's assets, but it did not reorder the private affections of a lifetime. Reconciliation, if it were ever to happen, would require more than legal rectification. It would require an epistemic humility and a willingness to see the other's experience as equally true. That did not arrive. Governance of the foundation matured in the ordinary ways institutions do. We appointed a treasurer with municipal bond experience, recruited board members who combined legal knack with lived expertise, people who had themselves been caregivers, and we drafted bylaws that specified conflict of interest policies, term limits, and a requirement for an external audit every 3 years. I insisted on a board composition that included at least one sibling of a person who had passed through the probate system. That lived perspective mattered for keeping the mission grounded. The reforms we helped enact were not the end of the story. New cases surfaced that tested the system's seams. In 2023, for instance, a neighbor called about a woman whose adult son had filed an emergency petition and moved assets into a guardianship trust while she was in the hospital for a treatable infection. The bank had complied with a court order before the protective accounting statute had been fully implemented in that county. The foundation responded with an emergency grant to fund counsel, and the county court, relying on the statutory amendments and on precedent from our earlier cases, placed the assets under a court-appointed trustee while proceedings continued. Incremental change, again, made a difference. What feels notable now, more than a decade after the trial that centered my life around legal evidence, is how process has displaced personality as the engine of consequence. Where there was once a single public drama, the accusation of incapacity, a family in shards, there are now procedures that press pause, that require corroboration, that route transactions through neutral eyes. Legislation can be evaded, courts can be imperfect, humans remain fallible. But each procedural stop we installed, the requirement for forensic accounting, the bank reporting threshold, the appointment of independent fiduciaries, makes coercive control more expensive to attempt and easier to contest. These are the accumulative repairs that, over time, reduce incidents of harm. As I plan what remains of my own time, I think in timelines and handoffs. I have written a continuity memo that describes how to run the fellowship, the audit timetable for our endowment, and step-by-step protocols for emergency grants. I have designated 3 successors to the executive director role, each staggered in appointment to preserve institutional memory. We created a small endowment fund specifically for legal defense of pending cases, seeded, in part, by funds that were restored from the estate. Those practicalities are the kinds of inheritance that feel truer than public accolades. There are still nights when I sit on my porch and play the playlist he loved, and there are mornings when the lab notebook sits open on the kitchen table like an unfinished letter. Memory, in the last analysis, is not opposed to systems building. Rather, it can be its animating fuel. The personal trial that began in January 2011 set me on a course of civic repair. It taught me, painfully and with clarity, that private harm requires public remedy. The Foundation's work has no definitive end. New petitions will be filed, new statutes will need refining, and new families will seek counsel, but the scaffolding we built gives those families a fighting chance. I remain for now, engaged at a distance, advising on policy, mentoring fellows, tending the garden that taught me the value of slow accretion. At the same time, there is a new legislative initiative on the horizon. A comprehensive guardianship reform bill that would standardize reporting thresholds across counties and impose a registry for professional fiduciaries. We expect hearings in the spring, and the Foundation will be there to testify. The story that began with a petition that called me mentally unfit has become, over the course of more than a decade, a history of modest, cumulative reforms. Legal tools and human practices that make it harder to weaponize grief and easier to sustain care. I will not claim that the arc is straight. Change has been incremental, and the ambiguities remain. But if history favors accumulation over spectacle, then the work we have done will, I hope, be judged by those who come after us as a durable, practical inheritance rather than as the last word on a family dispute. We went to those hearings in the spring as planned, spring 2024, and what I had expected to be a single day of testimony stretched across 3 days of committee work and public comment. The bill, as introduced, would have set uniform reporting thresholds, created a registry for professional fiduciaries, required bonding and continuing education for those who served in paid capacities, and mandated an electronic interface between probate courts and financial institutions. Its sponsors framed it not as punitive, but as infrastructural, a set of plumbing repairs for a part of government that had long been allowed to run on habit and trust. The first day belonged to survivors. I sat at the back of the hearing room. A woman whose brother had used a conservatorship to liquidate the family farm in 2016 described what it felt like to watch land that had been in her family for a century disappear for a promissory note. A former judge recounted the pressure judges face when emergency petitions arrive at midnight. He argued for mandatory judicial training and for the independent fiduciary triggers we had seen in our statutes. A bank compliance officer described the technological barriers and the costs of retrofitting systems to flag disputed accounts. He was candid about the institution's uncertain appetite for intrusive reporting. A geriatrician testified about cognitive assessments and the danger of rushing determinations of capacity in acute medical settings. The tone was granular, sometimes pained, and sometimes weary. People who had been dealing with the same errors for years. On the second day, lobbyists arrived. There were faith-based groups that worried the registry would deter volunteers who had long served as unpaid guardians. There were representatives of financial institutions who urged us to temper data reporting requirements in the name of customer privacy and to limit the scope of triggers so small routine transfers would not be ensnared. The professional fiduciary community split. Some welcomed oversight as a way to professionalize and to distinguish honest practitioners from a handful of bad actors. Others feared licensing would entrench incumbents and raise costs for families who used modest paid help. The tension was familiar. Reform has winners and losers, and good intentions collide in the marketplace of consequences. The Foundation's testimony was technical. We produced our datasets, the pilot clinic metrics from 2018 to 2019, the outcomes from cases the Foundation had funded, the forensic accounting logs mandated by the 2017 amendment, and we told the committee what the numbers suggested. Where statutory friction had been introduced, suspicious transfers fell. Where judicial training was more robust, the court was less likely to grant emergency control absent corroboration. We also offered an implementation plan with staged costs and concrete timelines. Because the Foundation held some funds that had been restored from the estate, a portion of that $4 million that had been the legal and emotional fulcrum of my early fight, we were able to underwrite a portion of the registry build and the first 2 years of continuing education subsidies for fiduciaries serving low-income decedents. The committee's markup was slow and, at times, brutal. Amendments arrived from unlikely quarters. Some tightened protections and added enforcement tools, others weakened triggers or deferred them to pilot programs in urban counties. The version that left committee in late summer of 2024 was, in legislative terms, moderate. It standardized reporting thresholds at the state level. Transfers above $25,000 or those involving real property would require immediate electronic notification to the court. It established a public registry for professional fiduciaries with a basic background check and bonding requirement for paid practitioners, and it authorized grants for counties that needed technological upgrades to comply. It did not impose licensing. It required, however, that any fiduciary on the registry submit annual fee disclosures and complete 8 hours of continuing education annually, an attempt to balance oversight with access. The legislature passed the bill in the 2024 session. The governor signed it in October 2024, calling it Common Sense Guardrails for Families in Crisis. Implementation was phased. Counties were given until January 1, 2026, to bring court systems online with the new reporting interface. The registry opened for enrollment in March 2025, and the bonding and continuing education rules took effect on July 1, 2025. The state set aside $2.6 million in grants to support rural county courts and small banks' compliance costs, funding that drew, in part, on the Foundation's advocacy and testimony that pointed to technological deficits as a major barrier to enforcement. The next 18 months were a school of hard knocks. Building an electronic interface across diverse court management systems exposed brittle architectures and vendor contracts that had gone unexamined for decades. Rural banks worried about the liability of reporting errors, and the language of the statute had to be clarified through emergency rulemaking to create safe harbors for good faith reports. The registry attracted hundreds of applicants, some of whom were eager to comply and to embrace formal standards. Others discovered that bonding was prohibitively expensive and dropped out, a reminder that reform can carry transactional costs that fall disproportionately on small fiduciaries and family-run trust companies. The foundation shifted its strategy from advocacy to implementation assistance. We used endowment income and a discrete tranche of the restored funds to create a compliance bridge grant, a program that reimbursed small fiduciaries for bonding costs in their first year and that subsidized continuing education scholarships. We partnered with a local university to host the registry's educational modules. The modules combined legal content with ethical scenarios drawn from anonymized case files in our archive. The lab notebook, digitized under the archive's access terms and used as a pedagogical object, was now a teaching tool. A scientist's methodical entries became a metaphor for procedural rigor in lawyering. By the fall of 2025, we had preliminary outcomes to show. In the 25 counties that had fully implemented the reporting interface, suspicious emergency transfers, those we defined as transfers that would later be reversed or shown to have inadequate corroboration, fell by 33% from a baseline period that averaged calendar years 2017 to 2019. Where independent fiduciaries had been appointed under the statute's evidentiary triggers, litigants reported faster resolutions and fewer reversals. The numbers were not uniform. Pockets of the state showed little change, often where courts lacked staff to process reports or where small banks had been slow to participate. Still, the aggregate shift was measurable and defensible. Not all developments pleased me. There were 2 legal challenges filed in late 2025 arguing that the registry requirement infringed on privacy and that mandatory electronic reporting of customer transfers violated federal banking secrecy rules. The litigation was narrow in scope, and the state responded with detailed memoranda showing that the statute had been designed to comply with federal law and to protect customer confidentiality through secure transmission protocols. The cases were disposed of by early 2026 at the district level in the state's favor, though one challenged aspect continued on appeal. That was the kind of gradual adjudication one expects when statutes change the operating environment for private institutions. The foundation continued to collect data and to publish annual reports. One finding surprised even our most seasoned analysts: standardized thresholds and the registry did more than stop outright theft. They reduced opportunistic unwinding of wills and inter vivos transfers that had been prompted by contested medical prognosis. The requirement for a forensic accounting in emergency petitions changed the cost-benefit analysis for potential abusers. And the registry, by making it easier to identify repeat players who had patterns of excessive fees or poor accounting, created reputational incentives. The court clerks began to treat the registry as a resource for verifying who was handling other estates in the county and what complaints had been lodged. It did not eliminate harm, but it raised the bar. Across these institutional shifts, my private life kept its small rituals. The lab notebook remained at the archive and on my kitchen table, in both digital and paper form. Scholars requested access and 2 published articles. One in 2025 on the history of fiduciary reform, and another in 2026 on legal ethics and guardianship, cited my file as an example of how individual case studies can illuminate system failures. I continued to play his playlist on the porch, and the garden I tended responded to the seasons in patient, indifferent rhythms. My parents grew older, slower, practical contact continued where necessary, and there were occasional exchanges about medical appointments and logistics. There was no dramatic reconciliation, no sudden thaw of decades of mutual narratives, but there were fewer public entanglements. Time, in its steady way, dulled some edges without revising the shape of the wound. International interest crept in. Delegations from 3 other states requested briefings in 2025, and by early 2026 5 states had introduced bills modeling elements of our reform. Some copying our registry idea, others adopting our electronic reporting thresholds. The National Academy of Elder Law Attorneys asked the Foundation to submit best practices drawn from our decade of casework. We did, and the document now circulates in continuing education modules beyond our state. This diffusion pleased me because it suggested that what had been forged in the pressure cooker of my case could serve as a prototype for others. It also cautioned that diffusion produces variation. Other states adopted diluted versions, and the impact there was predictably uneven. Not all of our work was legal or technical. Recognizing the strain placed on families, We expanded the foundation's counseling grants and established a small aftercare fund that paid for grief counseling and financial planning for people who had been subject to contested conservatorship. The felt harm of being accused of incapacity cannot be reduced to court orders and bank flags. It was psychological and social, and we tried, clumsily and sometimes successfully, to meet that need. A modest evaluation in late 2025 suggested that families who received integrated legal and psychological support were more likely to reach settlements and to restore relationships than those who did not. Causality was messy, but correlation suggested a path worth pursuing. The registry and the new statutes also forced a conversation about who gets counted as a fiduciary. Family members who accepted unpaid duties, neither supervised nor required to bond, expressed resentment at what they viewed as professional intrusion. We heeded that critique. The law continued to exempt unpaid family guardians, but we launched an outreach program in 2025 offering voluntary training and a family fiduciary toolkit that families could use to document decisions, collect contemporaneous notes, and set thresholds for transfers. That toolkit, distributed free, became a modest but surprisingly popular resource. It operated on the simple principle that paperwork, while it cannot substitute for compassion, can deter predation and create the evidentiary scaffolding that courts find useful. There were also human stories that refused to settle into policy papers. In late 2025, a woman contacted the foundation whose parents had, in 2012, been the subjects of a hurried conservatorship. She had been 22 then. The family dynamics had calcified. Now 35, she told me that she had used our online toolkit and that the registry had helped her identify an honest, modestly priced fiduciary who shepherded her parents through a final estate without the rancor she had feared. She said she felt as if the system, imperfect though it was, had let her family keep an ordinary life instead of becoming the subject of a public spectacle. Those modest reports were less thrilling than a headline, but they were what sustained me. As the foundation matured, so did its governance. The staggered succession plan I had written into the continuity memo had been tested when the first of my designated successors took a 2-year leave to care for an ailing parent. The board's requirement for an external audit every 3 years revealed one accounting irregularity in 2025, an administrative error in grant disbursement that our audit flagged and that was corrected within months. These were the small, humbling administrative chores that public work requires, and they underscored that mission-driven organizations are not immune to human error. The coming legislative cycle, however, already presented new challenges. By early 2026, a proposal surfaced to extend registry requirements to non-resident fiduciaries who managed assets in-state through digital means. The state legislature's technology committee framed it as closing a loophole. Fiduciaries could relocate to low-regulation states and continue to manage in-state trusts by remote authorization. That bill promised nationwide ripples and prompted an intense debate about interstate commerce and choice of law. We expected hearings on that proposal later in 2026 and began preparing testimony that would emphasize reciprocity and harmonization rather than parochial restriction. I am aware, too, that the narrative arcs we prefer, clear enemies, public triumphs, are rarely the plots of real institutional change. Reforms create new work for regulators and create incentives that will, in time, be gamed in new ways. A savvy actor in 2026 might, for instance, create intermediaries who appear compliant on registries but who use contractual subarrangements to evade bonding requirements. Anticipating such adaptations is part of the work, building monitoring and metrics into the law so that it can be iteratively refined rather than awaiting collapse before amendment. The Foundation's archive continued to draw researchers. In the spring of 2026, a former fellow published a comparative study in which she used the anonymized files to show how different courts treated identical factual patterns in 2011, 2017, and 2024. The narrative the research produced was not heroic, it was patient. It showed how rules, and the mundane enforcement of those rules, accumulate to create different lived experiences for people like me. The lab notebook in that account served as a symbol, an individual's methodical record of experiments and failure that, when placed alongside court dockets and accounting ledgers, testified to the power of process. As the state prepared for further statutory refinements, the Foundation leaned into 3 priorities. First, continuing to fund legal defense for immediate cases where assets might be moved before courts could intervene. Second, pushing for national conversations about reciprocity in fiduciary registries. And third, expanding prevention through education, reaching hospitals, clergy, and primary care physicians with materials about the risks of snap judgments regarding capacity. Those initiatives were pragmatic. They recognized that the most vulnerable moments remain medical crises and family grief. Personally, I feel less compelled to be at the center of public testimony. I still testify when it matters. People ask me to recount the trial that began in January 2011 because the chronology itself is evidentiary, the ways the legal system reacted, the legislative fixes, the iterative learning. But I also spend more time mentoring. The 3 successors I named continue to rotate through executive responsibilities in the manner I planned. The staggering of their appointments indeed preserved institutional memory. I am content to sit with the younger lawyers, to read their memos, to point out where the law's geometry will press against human fallibility. There will be more cases. There will be more hearings. The $4 million estate that once caused a family rupture has, imperfectly and with friction, seeded something that endures and that complicates the arithmetic of loss. The reforms we helped craft do not eliminate betrayal. They make it harder to proceed in the daylight without witnesses, ledgers, and audits. They redistribute the locus of control from private actors acting quickly to public processes that require documentation. That redistribution is messy and contested, and it will require sustained attention as actors adapt to new incentives. I do not pretend that this trajectory ends in moral clarity. The story moves forward, in my view, not toward a tidy victory but toward a repository of practices that future litigants and lawmakers can draw upon. I remain in the middle distance, mentoring, advising, and tending the slow work of accretion, and I expect that the registry, the continuing education programs, and the electronic reporting regime will continue to be refined in response to unforeseen behaviors. The past 15 years have taught me that good law must be paired with patient administration and with an ability to return and revise when the world changes. I will continue to do that work, to prepare the next generation of advocates and to guard the small practices, note-taking, audit trails, forensic accounting, that turned my private loss into a public instrument for repair. The hearings convened in November 2026 as we had anticipated. The Technology Committee drew a packed room and a long docket. Testimony from our foundation, from fiduciaries who had migrated to low-regulation jurisdictions, from elder care advocates and from a representative of the National Academy of Elder Law Attorneys framed the debate not as an abstraction but as a set of trade-offs. I testified on the chronology that had begun for me in January 2011. I recited dates, the petition filed, the emergency hearing, the inventory of assets that revealed the $4 million estate. Because chronology itself had been evidence in the policy arena, it taught lawmakers where delays mattered and where notice could still prevent harm. The committee adjourned with instructions to staff to draft a compromise emphasizing reciprocity and routine audit markers rather than a blunt territorial closure. Late in 2026, the staff draft incorporated 2 features we had urged: a reciprocity clause for out-of-state fiduciaries that required a short-form registration and a defined threshold for electronic reporting, and a pilot provision for randomized compliance audits for fiduciaries managing estates above a numeric threshold. Those pilots were authorized when the legislature convened in January 2027. The bill passed with amendments in April 2027. The passage did not feel like vindication so much as a recalibration. Lawmakers had accepted that the registry could not be a nationalist barricade. It would be a node in a federal patchwork, one that invited comparison and, critically, monitoring. The pilot audits revealed predictable seams. In the first year, auditors discovered that some intermediaries had inserted contractual layers that obscured ultimate control. Our earlier warnings about contractual subarrangements proved prescient. The Foundation convened a workshop in September 2027 to draft statutory language closing those loopholes, and by spring 2028 several states had adopted similar tightening amendments.